Hello and welcome to Quadcast, Quadrant Chambers regular discussion forum looking at news, hot topics and legal developments in the world of commercial litigation. The format, as you know, is very simple. Drink, talk, chat. Drink. Well, I am drinking a delicious glass of champagne. It is the final Quadcast of this series. Talk, we're going to talk about a legal topic. We're going to talk about exclusion clauses this week and the recent case of CNM Estates. Chat, we want you to join in. You can email us at quadcast@quadrantchambers.com or you can chat along in the YouTube function if you're watching this live. And hosting Quadcast, this final one of the series, with me at Poonam Melwani's holiday home on the Suffolk coast is Poonam Melwani, Joe Sullivan and Claudia Wilmot-Smith. Hi guys, so we're together, not through Zoom, not through a computer screen, actually here, distanced and in the fresh air, looking out over the sea. Let's do some catch up. Poonam, what's your news this week?
Well, I mean, I'm on holiday, woohoo, but, which actually has been fantastic. There's 13 of us staying in the house, but we've taken turns with the cooking, which has been great. But the most exciting is having all of you here. Though it was horrible not being able to hug. We did our elbow thing from a distance, but I can't wait to give you all a proper hug. But Joe, thank you all for driving here today, and Paul all the way from France as well.
Well, I didn't drive all the way from France, just to be clear.
But Joe, what's your news? You've done even more driving today.
Well, yeah, possibly today, although not as far as France. Yeah, I've been, this week has been a week of sort of things getting a bit more back to normal, I think. I've been out to the zoo to see some animals, which was different to what I'm used to, different to a normal zoo experience, but still good fun. Next week I'm going to see my parents, which is really looking forward to. It's been so long. So yeah, I think things are slowly getting back to normal. How about for you, Claudia?
Yeah, slowly getting back to normal. The gym's open, which made me really excited till I remembered that I hurt my ankle. I tried doing a press up for the first time since March. I managed a press up and then remembered that they're terrible. And had a road trip here with Paul and Emily, our producer. We road tripped to Suffolk and I got greeted with a glass of champagne on arrival. So thank you for the lift and thank you for the champagne, guys. Paul, I guess our road trip was the highlight of your week too.
The road trip was the highlight of my year, I think, actually, to be fair. Apart from...
Stop talking at any point.
No, she told us about all the cases. That was for half the journey. So the road trip was great, but I have bought 2 electric bikes for use on holiday, and where we are on holiday in France is very hilly, and I have to say that electric bikes, I can't recommend them enough.
Are you in like an OAP biker gang now?
This is something I learned about Paul on our road trip.
Electric chair things.
I want to be in a biker gang, said Paul Downs at about 11 a.m. this morning as we were going through London.
Was that a bike gang? That was a BMX bike gang. Anyway.
Yeah, exactly.
We digress. I'm so sorry. But electric bikes, fantastic. I can't recommend them highly enough. Before we go and talk about the topic this week, we should show people watching where we are because it is spectacular. Can we show a shot of the sea? So to my asking a little bit about Canada Steamship, because I like this case. The facts are great. It's a case that originated from an event in the 1940s, 1944. And what had happened was the UK government, the King, let out land that it owned in Montreal, Canada, to various companies. And one of those major companies was the Canada Steamship Company. So there was a lease in place between the King and the Canada Steamship Company. And the lease contained an exclusion clause. And the exclusion clause was an indemnity. It wasn't an exclusion clause, it was an indemnity in favour of the lessor, so in favour of the King, and it said the lessee shall at all times indemnify and save harmless the lessor from and against all claims and demands, loss, cost, damages, actions, other proceedings, by whomsoever made, brought or prosecuted in any manner based upon occasion, so on and so forth. So it's a very broad exclusion clause. And what happened was that the doors on one of the warehouses as part of this land didn't work. So the Canada Steamship Company called up the government and said, we want some of your workmen down here, please, to fix the doors. So they duly came down to fix the doors. And they changed the doors, but on the door there was a bolt. And the bolt had to go into a bolt hole. And the bolt hole wasn't big enough, the one they brought with them, for the bolt. So rather than order a new bolt hole, they decided they could do a sort of a bodge job. So they took out an oxyacetylene torch and started to adapt this bolt hole to make it bigger. And in the process of doing that, there was some cotton bales nearby, the sparks flew, and the whole thing went up, giving rise to a lot of claims. And so the Canada Steamship Company faced a lot of these claims, so they sought to claim against the king. And the king said, well, no, you are to indemnify us for the claims that have been made. We. Don't, I'm losing my train of thought already. Look at this indemnity clause. This covers it. All claims. And Lord Morton said, no, if you're going to exclude or have an indemnity to cover your own negligence, i.e. the king's servant's negligence, if you're going to have an indemnity for that, you've got to use clearer language. You've got to use the word negligence. And that is the case that has guided us all through. But the first nail in the coffin, as I see it anyway, was the case of HIH Casualty and Chase. Claudia, you love this case, don't you? Some glamorous... You look like a film star. So tell us about HIH Casualty.
HIH and Chase Manhattan is a case about Barbra Streisand movies. Ish. It's a case. Chase Manhattan provided funding for films, including a Barbra Streisand movie, which did not make as much money as anticipated, and so they wanted to claim on their insurance. The insurance had been broked by their agent Heath, and the insurers sought to avoid the policy for misrepresentation and non-disclosure. There was a pretty broadly worded clause that says the insured will not have any duty or obligation to make any representation, warranty or disclosure of any nature, express or implied, such duty being expressly waived by the insurers, and shall have no liability of any nature to the insurers for any information provided by any other parties, and any such information provided by or non-disclosure by parties including but not limited to Heath, who are the agents, shall not be a ground or grounds for avoidance of the insurer's obligations. So the insured said, you, the insurers, cannot avoid your obligations under the policy, and I feel like I've just said the word any 3,000 times. It's in there a lot, right? It's pretty broadly worded. But, said Lord Sumption, this was really an all-star case. I mean, it's not just Barbra Streisand who's in this. We've got Lord Sumption, we've got Lord Grabiner, we've got Lord Hoffman, we've got Lord Bingham. Lord Hoffman was on. Lord Sumption said, if you don't expressly refer to negligence, you don't exclude negligence.
The word negligence wasn't in the clause.
The word negligence was not in the clause, and he relied on Canada Steamship and said, Lord Morton was very clear, if you don't say negligence, you're not excluding liability for negligence.
Well, you can under the second then.
Whilst they are wide enough to restrict liability for negligence, the any that I've just said 3,000 times, under the second limit, he says you could read this clause as relating to innocent non-disclosure or innocent misrepresentation. Insurance contracts are contracts of utmost good faith, and so, but for this clause, you would be liable for innocent misrep or non-disclosure, so the clause should be read as confined to that only.
Now, let me just make the point in answer to your point, Poonam, now. Let's not forget, Lord Morton had 3 stages. Stage 1, do you use the word negligence? Okay.
Answer no.
Answer no. Stage 2, if you don't use the word negligence, are the words sufficiently wide in their ordinary meaning to cover negligence?
Answer yes.
But stage 3, if you can identify a possible head of damage that wouldn't be caused negligently, the existence of a possible head of damage other than that of negligence is fatal. Fatal to proffer ends, not follow.
And you said under limb 3, they say, well, it could be innocent.
Exactly,
right?
And so they said fatal. The argument was Lord Morton's decision means that that's fatal. Gunning hard in the other direction, enter stage right Lord Grabiner, who said this excludes not just liability but fraud. So he was pretty strongly the other way. We had a first instance decision where they said, I think they sided with Sumption. The Court of Appeal said it excludes everything, including fraud. The House of Lords said the words are wide enough to exclude negligence, and there are good commercial reasons why they would exclude liability for negligence, so they should be read to exclude liability for negligence. And I think Lord Hoffman was looking through the other end of the telescope to Lord Morton. He said, there's nothing inherently improbable about excluding liability, and he referred to the fact that Canada Steamship was a decision that was before UCTA, when the courts were really trying to read exclusion clauses. There was no other way of cutting out onerous exclusion clauses. And so he says there's a different approach now. Actually, you have other means of relieving yourself of the burden of unreasonable exclusion clauses.
And what was the reaction? Because, okay, so you say this is the first death knell to Canada.
I say, yeah.
I understand that. And what were the commentators and people saying after it coming? Does anybody know? Were they saying this is a travesty?
No, I don't think they were. I
don't think they were saying it's a travesty, but I think people were saying not really.
It's death by 1,000 cuts, because all these judges say, "Oh yeah, well, it's very important, Canada Steamship, but it doesn't tie our hands. It's a sort of like a guideline that we can follow." That just means they follow it if they like it, and
they say it's not a code. In HAH we have the House of, because the other thing about Canada Steamship is Privy Council, whereas this is the House of Lords, and they said it's not a code, but it is an approach to construction, and so you have to take it into account when looking at the language. It was 2003. Okay. It was reported in 2003, so it was recent-ish, but not that recent.
But Poonam, you've got a.
Yeah, so the case I was going to look at was the Suckle 3, and that's a 2010 case, and the judge. And
I know that because Poonam was doing it when I was in pupil. I was her pupil. I've got a Suckle 3 folder in my pupillage folder. It's like brings back memories.
You don't look that old, Claudia, or Poonam.
Thank you. Thank you. So Hamlin was the judge in the Suckle 3 in the commercial court, and of course now he's in the Supreme Court, so his take on life might be interesting. And this case concerned the clause 13B of the NYP form, so a standard clause, and it's much shorter than the one Claudia read out, and I can give you the whole one without saying the same word a million times. In the event of the carriage of deck cargo, owners are to be and are hereby indemnified for any loss and or damage and or liability of whatsoever nature caused to the vessel as a result of the carriage of deck cargo. There's something else that's not relevant. What happened was there was a casualty at sea because the deck cargo shifted. There was loss of deck cargo. The vessel had to put it into a port of refuge. So there's deck cargo damage, there's other cargo damaged, and lots of expenses. The arbitration, Claudia, were you with me for the arbitration or the first instance? So
first instance.
I did okay. Okay, we'll come to that in a minute. I did the arbitration. The arbitrators found that an effective cause of the casualty was owner's fault, a failure to exercise due diligence to make the vessel seaworthy, and insufficient checking of the lashings during the voyage. So classic owner's fault. I was for charterers. So way, hey, good. But no, the arbitrators held that the indemnity clause was wide enough to make charterers not only unable to claim for their own loss of the deck cargo, but had to indemnify owners for everything else.
But you weren't there for that?
No.
So that wasn't your fault?
So then comes in Hamlin, who's a really good judge and really open to persuasion by really good pupils, yes.
Well, I'm afraid, Claudia, neither you nor I can take the credit for what happened at first instance, because a leader waltzed in to lead me in front of Hamlin.
You said first instance, but it was an appeal.
There was an appeal
arbitrator.
Against the arbitrator on a point of law of general importance, because clause 13B is a widely used clause. And Hamlin said various interesting things. Let me be clear right now, he reversed the arbitrators on the point.
First of all,
just as in Canada Steamship itself, mine is an indemnity clause, and he made the point that the rules of the same principles apply to indemnity clauses as exclusion clauses, but he said with even more force, because it's even more unlikely that someone would not just allow someone not to be liable to positively indemnify them against their own negligence or wrongdoing. Yeah. He was very much affected by the main duty under the contract, what he called the overriding duty of seaworthiness, and which we'll hear, I think, from Joe, has got a new catchphrase to it, the meaningful obligation. I quite like that, but I'll let Joe tell you about that. And he was saying it's very surprising to exclude liability in relation to your fundamental overriding duty. And you'll all remember that in photo production, the House of Lords actually said, no, you can still exclude, and they tried to row away from this fundamental duty. But Hamlin was very affected by that. And he did apply Canada. He said, using Canada, it's wide enough to exclude negligence, but not in the context of the overriding duty, and there are other non-negligent responsibilities you could have. I'll just make one other point. The phrase I had in that clause is indemnify for liability of whatsoever kind. And he accepted that there were various first instance cases that have held of whatsoever kind is the same as howsoever caused or howsoever arising. But he said it all depends on the context, and in this context, it ain't. It's not.
Right. Whereas in HIH, there was nothing surprising about excluding liability for negligence, because Chase had no idea, really, anything about the risks that they were insuring.
Understood. So, Paul, you're going to tell us, because you want to say Canada Steamship's gone, of another case.
Well, it's another case where poor Lord Morton gets ignored in truth. Not ignored. Always pay lip service, but don't actually then apply the rules. So this is a case where I came second, regrettably, Mere Steel and Morris. What had happened here was that we had a steel mill. Alpha Steel was a steel business in Newport, South Wales, and its parent company at that stage was Liechtenstein Anstalt, Lictor, and they had put in the steel mill and paid for the steel mill and put it in the premises. Huge thing, 300, I went to see it, 300 feet long, massive. And this mill was, in a letter, 3rd of April 2000, it was stated that Alpha Steel accepted that Lictor owned this huge steel mill and could remove it anytime it wanted. Okay. In 2007, Alpha Steel went into administration, and the administrators wanted to sell off the business, and they did so by virtue of a hive-down agreement into this creature, Mere Steel. And the hive-down agreement, dated the 11th of July 2008, was therefore a tripartite agreement between Mere Steel, which is just a shell, I mean that's just a nothing, SPV, and the administrators and the purchaser. And Lictor sued because Lictor said, well, in transferring the business and the land, what you've done is deprived me of my right to remove the steel mill under this letter of the 3rd of April 2000, and that is procuring a breach of contract, and it's an unlawful act conspiracy. Now, in the hive-down agreement, there was a clause, it's a very short clause, so I'll read it to you. The purchaser agrees that it shall be responsible for settling any claim made against it by Lictor Anstalt in respect of the hot strip mill situated in the property. They knew there was a potential claim, potential problem. And what I was acting for Mere Steel, and what we said is we want to join the administrators in this claim, because whilst we accept this clause would cover most claims, it says nothing about intentional wrongdoing. No. It's a bit like HIH. It doesn't exclude and if you're going to exclude liability for a conspiracy, which is an intentional tort, you need to say so with words. And Lord Morton's approach, we said a fortiori. If negligence, you have to use clear words. Intentional. Anyway, held no that the commercial context in which the agreement was made it clear that the parties intended that any claim, even an intentional tort like fraud or like conspiracy, that is included.
What was your clause?
The clause was, the purchaser agrees that it shall be responsible for settling any claim made against it by Lictor Anstalt in respect of the hot strip mill situated at the property. Well, I sort of see where they're coming from on it, I have to say. But it doesn't, my point is, it doesn't apply the rationale of Lord Morton's three stages.
So is your thing not that Canada Steamship is right, but it's just odd that it's not been overruled when people ignore it?
Yeah, my point is that it's a fantasy. What the most important thing in construing an exclusion clause is to look at the commercial context and then ask yourself, did the parties intend that negligence should be excluded, fraud should be excluded, whatever it is?
Because the third limb of the Morton test is, could it apply to something else? Is there some other line? Yeah. So they grappled around in the old days to find some other thing. Yeah. Whereas now they're going, no, hang on a minute, what is the real commercial purpose of this? And is it being defeated or not? Yeah. Would you say is a more realistic?
Yeah, I think that the commercial purpose, straightforward rules of construction come first. If they give you a complete blank page and you just don't know what to do, then maybe use Canada Steamship as a fallback. But it's not the guiding force. But Joe, April and Ellen, I think you're going to agree with me on this one, this sort of judge not following.
Yeah, I mean, controversially, I'm going to talk about a case that I didn't do. A colleague in Chambers was on this case, though, Max Davidson, and it was a decision of Stephen Hoffmeyer sitting as a deputy. It was about loss and damage to deck cargo where there were exclusion clauses in the bill of lading.
The shipping case, that's why you didn't do it.
That's the only reason I did. And it was a broadly worded clause again. Well, there were a couple of clauses, but similar. So, carrier incurs it shall in no case be responsible for loss of or damage to cargo, howsoever arising in respect of deck cargo. And Stephen Hoffmeyer had little hesitation in finding that clause did encompass negligence and unseaworthiness. And
so he obviously hadn't read what...
On Suckle, well, oddly, so the approach that he took was he said, I'm just going to think about what the ordinary meaning of those words is, and I think the ordinary meaning is that they include negligence and unseaworthiness. But then what I'll do is I'll go back and I'll check it against Canada Steamship and against other relevant cases. And when he said other relevant cases, he listed several cases, including Suckle. And then in his judgment, he has a heading for every case
except for
Suckle, which just is ignored. Right? Yeah. So I don't know whether that's sort of a drafting error or something like that. But yeah, he then says, oh, and funnily enough, I think everything confirms my view as to the meaning of the words, which is what the cases say, don't they? I mean, pretty much all of them seem to say these tests are helpful, but they're not something separate from the ordinary exercise of contractual construction. They just help you get to the right answer using ordinary contractual principles. And I suppose, I mean, it's quite difficult to see how that can be the case on the third element of the Canada Steamship test, isn't it? Because I think if you were to ask someone who had no knowledge of law, never heard of Canada Steamship, and you said something like, any claim howsoever arising, they would think that means any claim howsoever arising.
You might also think that means including a fraud claim.
No, well,
they always tend to say it doesn't include fraud.
Hang on, we're going to come to fraud later in the program. Don't mess around with fraud yet.
But the reality is that they would think it includes any claim, including fraud, wouldn't they? And so if you're going to adopt that approach, then I think the third limb of Canada Steamship just doesn't mean anything. And so I agree with you, Paul, that it's being ignored. Although I mean, I would say probably rightly being ignored.
This is the final Quadcast you saved to agree with me on something.
Yeah, hang on. We'll wait. Well, yeah, I do. I don't want to. Yeah, I don't want to go too far. But I want to know what a recently promoted Supreme Court judge thinks about this, Claudia.
Well, that almost made me feel like a recently promoted Supreme Court judge for a moment.
Big news on Quadcast.
You heard it here first.
Yeah, no, it wasn't me. But in JP Morgan and against the Federal Republic of Nigeria, it was a case involving a depository account held with JP Morgan, and it had strict instructions about how and in what circumstances to pay money out. Money was paid out in accordance with the mandate, but the Federal Republic of Nigeria said that it was in breach of a quince care duty because it was all part of a scheme to defraud the Federal Republic of Nigeria, and the bank should have been on notice. And so when the Federal Republic of Nigeria applied to reclaim the $875 million that had been paid out, the bank applied for summary judgment, saying the terms of this depository account make it clear that the quince care duty never arose in the first place, or if it did, then liability for damages is excluded. And anyway, an indemnity provision means that the claim fails for security of action. And it came before Professor Burrows, QC, sitting as a deputy judge of the High Court. And he says, well, it's a summary judgment application, so I have to assume that Nigeria can make out its case on the facts. And so I have to consider whether the contract therefore means that the claim fails. And he said, on the proper construction of the contract, there's nothing to prevent the duty arising from the first place, and you haven't excluded liability for breach, and the indemnity provision doesn't mean that you can be indemnified.
So it's a reverse summary judgment. The defendant was trying to strike out.
Yeah, exactly. and the bank appealed. And by the time they appealed against a decision of a part-time deputy judge of the High Court, and it got to the Court of Appeal, and the part-time deputy judge of the High Court had been made Lord Burroughs, a Supreme Court judge. And funnily enough, the Court of Appeal were like, yeah, he probably knows what contracts mean, actually. He can probably read a contract. So it's actually quite an interesting case because they consider different categories of clauses: an entire agreement clause, clauses which were said to be inconsistent with the duty of a quince care duty of care, and it was said, given this inconsistency, that must mean the duty never arose. Or they said if there was a duty, they considered exclusion clauses excluding liability, and then there was also an indemnity. So they considered the approach to construction in all of these cases. The entire agreement clause was said to mean that you're only under the contractual duties, you're not under any other duties. So if there's a duty of care in tort, you're not under it because it's excluded by the entire agreement clause. And the court said that's just not the case. There's nothing in this entire agreement clause to suggest that the ordinary common law duty of cares, which are opposed for good policy reasons, are excluded. Yeah. Then when considering that was what Professor Burroughs said, and they agreed with him in the Court of Appeal. When considering this inconsistency argument, it was argued that a different approach should be taken to clauses which aren't strictly exclusion clauses because they don't exclude liability for breach, but the argument is rather that this clause prevents a duty arising in the first place. So it was said these clauses which say things like you're not under a duty to make inquiries, for example, prevents the quince care duty from arising, and therefore whilst you would need clear words to exclude liability, you don't need clear words to prevent a duty arising.
Am I being a bit thick here? If you exclude liability by saying I'm not liable for a breach, and you exclude liability by saying I don't have a duty, then
well, they said the latter didn't require clear words. It was a different test. And I don't see why it should be a different test. It doesn't make sense to me but they said, look, there are these authorities which say it is a different test. Professor Burroughs said, actually, there is a good reason to have this duty of care, and if you are excluding the duty, you need clear words to do so. They appealed and they said that's putting an unacceptable gloss on it. There isn't this clear words requirement. And the Court of Appeal said he wasn't saying there was a clear words requirement, so we don't need to consider whether the test is different. But I think, looking at the quotes of Professor Burroughs' judgment in the Court of Appeal, he was saying you need clear words to exclude a duty, at least as clear as you would to exclude liability, for the reasons that Poonam's just said. Yeah. So I think he was right to say that, and even if it was a decision of a deputy judge of the High Court, it's Professor Burroughs, so that will stand. Similarly, exemption clauses, if you are trying to exclude liability for this, you need clear words, and there weren't clear words in this contract. The indemnity provision case, they said there was a clause saying you will indemnify us against whatever. They said that means if you sue us, you have to indemnify us against our liability to you. So any claim that you make against us will file for security of action, which was quite a bold construction and also failed. They said it's an indemnity against third-party claims. So they refer to Canada Steamship, but again, as in this way that Joe's talks about, right, which is it's an approach to construction, but what you're doing is construing a contract. You're not applying a code that was laid down to consider whether or not negligence or duty. So 2020,
Paul mentioned we've had a recent judgment. Has it clarified life for us, Joe?
I think, largely it's more of the same. CNM Estates was handed down by Mr. Justice Foxton in lockdown in June. It was a claim against receivers for breach of their equitable duty of care and skill in getting a fair value for the property. Mr. Justice Foxton examined 3 rules or principles of construction, so not just Canada Steamship, also the Gilbert-Ash principle, which is the idea that clear words are necessary before a court will find that a contract takes away a common law, or in this case, equitable rights or remedy. And also what he called the meaningful obligations principle, which Poonam touched on before, which is the idea that the court will not interpret an exemption clause so as to deprive the contractual undertakings of one party of all of their effect. And he held that all of these principles, including Canada Steamship, are helpful, but they're not separate rules, they're just helpful ways of applying ordinary contractual principles of construction. And there were 2 exclusion clauses in this case, one of which he held did cover negligence. That was a clause which said in effect, we're not liable unless it's gross negligence or willful default. But there was another clause where he held that it didn't cover negligence in circumstances where, in other cases, I think a more liberal approach has been taken. But on the other clause, he applied Canada Steamship and went through the stages and said, I don't think the clause works in this situation. So in one sense, you might think that's a reapplication or a firming up of the Canada Steamship principles. But I think in a very other, more real sense, you might take the view that because he'd found that another clause worked, he can do Canada Steamship.
It's an odd case as well, isn't it? Because these were two agreements, a debenture and an intercreditor agreement, entered into on the same day as part of an overall refinancing. And he's found that in one agreement, the parties intend to exclude a claim in negligence against the receivers, and in the other agreement, they've intended not to exclude. How do you reckon? And what's the result of that?
Yeah. Well,
how do you reconcile
that it's excluded? And I suppose, but that is rational, isn't it? Because you can only go so far with contractual construction. If the words say what they say, then you just have to.
Well, I know, but they're not. They're excluding an extra contractual duty. I can totally see that if contract A says you will be liable for these breaches of this contract, and contract B says you won't be liable for these breaches of this contract, obviously they fit together. But if they're both saying, well, in relation to these other freestanding duties, equitable duties, C, A says these are excluded, B says they're not excluded.
It's not saying they're not excluded. It's not saying they're not excluded. It's just not excluding them. So you could say, I agree to exclude A.
Party, one got the right clause.
Well, we all know the truth of it is, and the bank just says sign this. If you want the money, you sign it.
Poonam, we've got a problem.
Yeah, before I do that though, because I said earlier I quite like this new word, meaningful obligations. Okay. And as you were talking, maybe it's the blue sky, I started being philosophical. Are there obligations that aren't meaningful in a contract? I mean, they're all obligations. I'm not sure I like
good faith. Discuss. Oh wait,
Isn't
we've done that.
where the obligations that are not fundamental, but at the very core.
Fine, but meaningful is not good.
It's not a great label.
Okay, anyone of our audience who wants to suggest a good adjective, you understand the concept of what we're discussing here.
What's a meaningless obligation?
Yeah, well, so give us a word other than meaningful. Yeah. I've decided I'm not.
The main.
Now we've got a case study.
We have a case study.
And are we doing this on a vote?
Are we doing a vote?
We are doing a vote.
We've got a thumbs up.
So can we remind before we go to the case study just how people vote? Just tell them how to vote.
You always do that. I haven't got the faintest idea. Oh, Emily, we have a flip chart so that Emily can't give us chat functions. And we are going to put the camera on Emily at the end. So Emily, twist your hair up, do whatever you need to do, honey. What you need to do is vote on www.quadcast.vote. And it's a straight yes or no answer, but I'll give you what the problem is first. Big, large corporation are in the process of selling a subsidiary, Tiny Weeny Business Limited. Tiny stock-taking systems are known to be completely unreliable. And big, large corp do not want to assume any responsibility for the stock levels portrayed in Tiny's accounts, even if they prove to have been fraudulently manipulated. So they make Tiny's accounts available to potential purchasers, but on strict terms, just imagine the widest ones run, that in absolutely no circumstances whatsoever, howsoever, are they entitled to rely on them. The question is that sufficient to exclude liability for fraud? So if you think it is enough to exclude liability for fraud, it's yes, and it's no if you think it's not. So this is the sort of clause Claudia mentioned earlier, which is trying to stop the duty from arising in the first place. I'm going to go to Claudia first. What's your view?
There's a silence because yesterday I was fairly sure that this meant that no duty could arise, or it would remove any duty you might otherwise be to prevent accurate accounts. So it's not that it would exclude liability, but it would
you mean the thing we
exclude
just
the duty.
agreed earlier was stupid in relation to the case? Okay.
Yeah, so I've changed my mind. So I don't think it will exclude liability for fraud.
Okay, so you are a no.
I'm a no.
Joe.
I'm a yes. I think it does. Well, I certainly think that it should. I can well see
that
some judges.
Why though? Why?
Why? Because that's clearly what they mean.
So would it be the same for you that if it said, with the same wording, that we are not liable for fraudulent misrepresentations in the account, that would also be sufficient to exclude that? Or are you doing some distinction between the duty arising and the liability for the duty?
I think there's a distinction between the duty here. I would say they're non-reliant.
I was asking...
Sorry.
Yeah, I think that I think that there is a conceptual difference between those two ideas, but there shouldn't be a difference as a matter of principle.
So what do you say about this suggestion in HIH casualty that as a matter of public policy you can never exclude liability for fraud?
I think that's the conceptual difference, isn't it? Because you always have to analyse, don't you, whether there is a claim in the first place.
Yeah.
And so if a constituent element of the cause of action just never arises, then there just is no claim. It's not really a question of excluding liability, it's just that there is no liability.
That's where it was yesterday.
But the point is this, that, I mean, obviously we all know that in these situations, what the vendor is trying to do is not so much protect themselves against fraud, they're trying to protect themselves against a claim in fraud, good, bad or indifferent, because they want certainty, they want crispness, and so they want to get the message over to the purchaser. Yeah. Look, you buy this at your own risk, sold as seen.
But here they're saying they want to take away any responsibility, even if they have been fraudulently manipulated, because they're so unsure about their own systems.
Because they think, well, there might be a rogue manager down the chain.
And
Who knows?
There's a good commercial reason to allow clauses like this to have effect, isn't there? Because the alternative is that they don't give them the information at all, and then they don't even have the opportunity to investigate or interrogate the information.
Yeah.
So where are you on this one?
I say no, absolutely not. I think Joe's wrong. I'm sorry, Joe, but it's fraud, isn't it? The fraud unravels all. I mean, who said that? You know, it's just absolutely fundamental.
Fraud doesn't unravel all, though, does it?
The problem is that you can think of so many nuanced examples where the person who signs up to that had in mind a risk of fraud, which is in this sort of ring, and the fraudster, the vendor, flying in my face, is in fact got some scheme up their sleeve. Mm-hmm. So they say, look, sign this, it's fine. We're worried a bit about the stock take system. There's probably could be a problem with it. It might even be wrong. So just sign it, and that's what we're concerned about. Always knowing that actually what they've done is deliberately misstated the accounts in order to inflate the profits. And so unless you have a clear rule, you can never exclude liability for fraud. You're then in this sort of no man's land of, well, maybe it's excluded, maybe it isn't.
But this sort of wording, I think, would make it harder to prove fraud.
I'm assuming you can prove factual reliance.
Yeah.
I'm assuming you can prove that the intention to mislead the person, and if you need to, inducement. I'm assuming you've got your claim in fraud, and that what you're met with is this clause.
Joe, I'm feeling so guilty.
What do you say, Pooh?
Well, because
we're all against
I flip-flopped, as I have flip-flopped.
Me too.
Right, okay, we've got to tell people.
Did you also spend all yesterday thinking about this, as I did? I spent all of yesterday thinking about this.
I'm going to tell people, we did a rehearsal, yesterday, and all of us thought it was probably good enough to exclude liability for fraud.
And that's like all day.
Not producer Emily.
I will adopt the contrary position, I said, and I will seek to argue against it so that there's otherwise.
And we've all been persuaded by producer Emily.
And they've all now changed their mind, and the audience says
except
no.
Joe. Joe stood firm.
I'm standing firm.
Joe's standing firm. He says fraud does not unravel.
But look at the result.
So the result is, everyone, but you haven't had a night to flip-flop.
It's pretty narrow, though.
The answer is that 38% of you said that it would be sufficient to exclude liability. So 38% agreed with Joe.
Yeah.
And 62% of you agreed with the three of us. But all of you are more intelligent than us because yesterday we had the wrong answer.
No, but to be fair, I think a lot of those people voted at the last minute after they heard my argument.
I want to agree with Joe. I'm just...
So, God, we've come to the end.
That's it. So what do you do? Let's a quick wind up. So, Joe, what are you doing over the summer? What's your plans from here on in?
So you're going up to Yorkshire next week, going to the Cotswolds later in the summer. Just trying to stay away from Spain, I guess.
Soon
I've got a few more days of holiday and that's it. I'm working on a really, I have to be nice, a really wonderful case that's going to take up all my time till the end of the year. and I've got to get cracking on it. So I've got a few more days and then that's it. What about you, Claudia, honey?
Honestly, I'm considering adversely possessing this house. Like, it is so
Claudia,
nice.
I have a spare bedroom tonight because one of my kids left. We can find some clean sheets. You can have the bedroom tonight.
It is so nice here.
Back with us
It is
tomorrow.
pretty. It's pretty beautiful.
So if I get evicted, then I will be going to Tuscany.
Now we've got. Look, I'm sorry. You're going to Tuscany?
Yes.
Okay. Sorry, I interrupted you.
No, you sounded.
The reason was I didn't want to forget. We've got to show people Emily Saunderson, our producer, and also I think we should somehow flick a camera. So shall I change this camera around and just?
Oh my God, I might fall over. Emily, come sit here with us.
Hang on a minute.
No, you do what you want.
Yeah, Emily, come back.
Oh my God.
We can't.
People can just see. So. So I'm going to just move the camera.
So everybody, this is what's happened to my beautiful holiday.
So there we are. There is Emily. Wave Emily. There is Ben.
It's true.
Jacobs, Fisheye Productions.
Bucolic countryside scenes.
And I'm going to put the camera back there nicely. There we go. And I'll come back to my seat. And so that is it. That is our series of Quadcast. We may do something in the autumn. We'll let you know. You must subscribe to the Quadrant Chambers YouTube channel. We are trying to build up our subscribers. Subscribe. Recommend it to everybody. So all the seminars and webinars we put out, Quadcast, whatever we put out, you will get notice of. I just leaves me then to say thank you, Joe, Claudia and Poonam. It's been a privilege, been a pleasure.
Been great
thank
fun.
you, Emily. Thank you, Ben. That's great. And from the Suffolk coast, Thorpeness, good evening, everybody.
Cheers.
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 Cheers.